It's a difficult question because if you just live in Australia, the Australian privacy principles are for you. If you just live in the European Union and you don't really travel outside of the European Union, again, the Europeans' laws, the GDPR, are definitely the centre of your world in privacy. America is an interesting country because it's got so many, 51 states, I think. And the states have a lot of control in privacy law. They don't yet have a National Privacy Act. They are working on a concept towards that at the moment. But what that means is that the Californian law is relevant for people who live in California and for companies that have business representation in California for Californians. That's quite complex for us to understand, although in Australia we do have state privacy laws as well, but they don't tend to overlap against the national privacy laws. They tend to deal with the different strata of our society or our industry, often dealing with the state government institutions that we deal with or state-owned enterprises. If we think about ourselves, though, as globalised citizens through our data these days, we use Microsoft products here in Australia and Google products, Apple products, Samsung products. These global companies, offshore global companies, interact with our data constantly today. And so when we think about the different laws in the different countries that overlay that network of information that we're all relying on day to day, complexity does arise. There's no doubt that the Europeans with the GDPR have sort of jumped into, I guess you could say, pole position as setting a global standard for comprehensive privacy protection. Its consent requirements, for example, are among the strictest. They require explicit opt-ins when you are requested for consent rather than opt-out mechanisms. The specific purpose of collection or use of information must also connect to an acceptable legal basis. And these are drafted into their laws. There's only a handful of them, but it forces organisations really truly to identify, why am I using this information? Why is it important for me to collect Rob's information right now, or to use it in this way, or to transfer it to another party? Easy decline, easy withdrawal of consent are mandated, required under the EU's laws, and there are very high penalties for non-compliance, which have been certainly put into action by many of the regulators through the 28 countries in the EU, and have seen changes really take place in European organisations because they know that enforcement agencies are out there and are taking action where they see behaviour or personal information conduct which is not acceptable. In America, the Californian Act, it emphasises consumer control. It allows consumers to opt out of the sale of their personal information to third parties, and that's a very useful thing in this day and age. Businesses must also display consumer options very prominently. That's a great thing for, all manner of consumer information. You've got to be able to find it if you're going to read it, right? But it is, as I say, an example of a state law in the United States. It's a patchwork of laws. And so, if we look at it from the point of view of Australia, the CCPA is a little less influential, I think, in our own thinking here of our own laws and how they should develop. I think we look a little bit more to the Europeans and the GDPR. And I think that we look also to Canada and New Zealand as having similar systems to ours. The ideas might be a little different, but the concepts are often very much the same. Here in Australia, the Australian privacy principles, they provide a framework to help organisations and individuals evaluate context rather than providing prescriptive detailed rules. This does have a slight disadvantage. It frequently necessitates businesses or individuals to interpret the word reasonableness, or what's reasonable in a situation. But we do know that what's reasonable for one person or one business might not be reasonable for another for very specific personal reasons. And that's why that reasonableness test appears so often in our laws. It does give flexibility, and it allows people who might not be in the majority all the time, but if some personal information is particularly important and valuable to them, it allows them to be able to state their case, to an organisation. An organisation needs to be able to listen to it rather than just saying, oh, well, look, most people don't need that, so why would we worry about it? Vulnerable customers particularly, we think about as examples in this area. Enforcement in Australia has been generally less rigorous. We have had some new laws come in 2022 which have increased penalties and regulatory powers, particularly after we saw quite a number of data breaches in 22 and 2023 that impacted most, I would say, Australians were impacted by Optus or Medibank or Latitude Financial, some of the others that did occur. Limited individual rights for deletion of personal information is an interesting one in Australia. Some people argue that it's kind of there, but it's kind of not. What we do have definitely is a right to correct our personal information if it's become out of date or become irrelevant, or it's simply changed, moved house, for example. One of the things that does allow a person to do, of course, is to correct a piece of information by removing it and not replacing it with another piece of information. That deletes information currently, but it doesn't go back into history and delete historical information. So that's probably one of the key differences between the Europeans, who have a very specific right of deletion of all of their data, versus the Australian model. One thing that's interesting to understand is that in Australia there are many laws, and this is true of many countries, but in Australia we've got many laws that require businesses to retain information for a certain period of time. Deletion of personal information, on the one hand, is being matched in these cases by a requirement for businesses and organisations to retain information for business, taxation, or, for example, insurance purposes. And that can be a real tension between the right to delete versus the necessity to retain information.